Welcome back to Artificially Informed, the podcast series that takes an in-depth look at the Florida Attorney General's government in the Sunshine Manual 2025 edition. As always, this episode is produced with the extensive use of artificial intelligence. I write the prompts and review and edit all of the output. In today's episode 4, we shift our focus to Part 1, Section C, what meetings of members of boards are covered. Application of the Sunshine Law. 2, found on pages 21 through 24 of your manual. We'll be specifically examining how the Sunshine Law applies to board members attending meetings or serving as members of another public board, a board member meeting with his or her alternate, community forums sponsored by private organizations, confidential records discussions, and email text messages and other written communications between board members. Let's begin by understanding how the Sunshine Law extends to interactions between members of different public bodies. Segment 1. Board members attending meetings or serving as members of another public board. Board member meeting with his or her alternate. Starting on page 21, we look at board members attending meetings or serving as members of another public board. Several Attorney General opinions have considered whether members of one board may attend or participate in a meeting of another public board. First, under board members attending meetings of another public board, on page 21, Attorney General Opinion 99-55 states that a school board member can attend and participate in a meeting of an advisory committee appointed by the school board without prior notice of his or her attendance. However, the opinion cautioned that if it is known that 2 or more members of the school board are planning to attend and participate, it would be advisable to note their attendance in the advisory committee meeting notice. Furthermore, while commissioners may attend meetings of a second public board and comment on agenda items that may subsequently come before the commission for final action, if more than one commissioner is in attendance at such a meeting, no discussion or debate may take place among the commissioners on those issues. This was clarified in Attorney General Opinion 00-68. Accord Attorney General Opinion 98-79, which stated that city commissioners attending a public community development board meeting could express their views on a proposed city ordinance, but may not engage in a discussion or debate among themselves because the city commission's discussions and deliberations on the proposed ordinance must occur at a duly noticed city commission meeting. See also Attorney General Opinion 05-59 and 77-138. Next, under board members serving as members of another public board, on page 21, if board members also serve on a second public board, they may participate in the public meetings of the second board held in accordance with Section 286.011 Florida statutes and express their opinions without violating the Sunshine Law. Attorney General Opinion 07-13. As explained in that opinion, when 2 county commissioners are presently serving on a regional planning council, this does not turn a meeting of the planning council into a county commission meeting, and the Sunshine Law does not require any additional or different notice of planning council meetings because of the presence of these county commission members. Similarly, Attorney General Opinion 98-14 concluded that the membership of 3 city council members on the Metropolitan Planning Organization did not turn a council meeting into a Metropolitan Planning Organization meeting that required separate notice. However, because discussion of Metropolitan Planning Organization matters was planned for the council meeting, the City Council had properly included mention of such items in its notice of the council meeting. Additionally, in Attorney General Opinion 91-95, the Attorney General's office concluded that a county commissioner may attend and participate in the discussion at a public meeting held by the governing board of a county board on which another commissioner serves. However, in an effort to satisfy the spirit of the Sunshine Law, the opinion recommended that the published notice of the county board include mention of the anticipated attendance and participation of county commission members in board proceedings. Now on page 22, let's examine board member meeting with his or her alternate. The Sunshine Law does not apply to a meeting between a board member and his or her alternate. This is because the alternate is authorized to act only in the absence of a board or commission member, meaning that, in effect, there's only one decision-making official present. This was the conclusion in Attorney General Opinion 88-45. Segment 2, Community Forums sponsored by private organizations and confidential records discussions. Let's move to Community Forums sponsored by private organizations, also on page 21. A candidates' night sponsored by a private organization where candidates for public office, including incumbent city council members, speak about political philosophies, trends, and city issues, is generally not subject to the Sunshine Law. This holds true as long as the council members avoid discussing issues coming before the council among themselves. This point was made in Attorney General Opinion 92-05, compare Informal Opinion to Jove, January 12, 2009, which concluded that a public forum hosted by a city council member, with other city council members invited to attend and participate in the discussion, would be subject to Section 286.011 Florida statutes. Similarly, in Attorney General Opinion 94-62, the Attorney General's office concluded that the Sunshine Law does not apply to a political forum sponsored by a private civic club during which county commissioners express their positions on matters that may foreseeably come before the commission, provided the commissioners avoid discussions among themselves on these issues. And C, Attorney General Opinion 08-18, which states that participation by 2 city council members in a citizens' police academy does not violate the Sunshine Law. The educational course is not changed into a meeting of a board or commission by the attendance and participation of members of the city council in the course work of the academy. However, the manual cautions that care should be exercised to avoid situations where private political or community forums might be used to circumvent the statute's requirements. Attorney General Opinion 94-62, as the Florida Supreme Court stated in Town of Palm Beach versus Gradison, 296 Southern 2nd, 473, 477, Florida, 1974, the Sunshine Law must be construed so as to frustrate all evasive devices. For example, in State versus Foster, 12, Florida Law Weekly Supplement, 1194 Alpha, Florida Broward County Court, September 26, 2005. The court rejected city commissioners' argument that the Sunshine Law permitted them to attend a private breakfast meeting where the sheriff spoke, and commissioners individually questioned him but did not direct comments or questions to each other. The court denied the commissioner's motion for summary judgment, ruling that the discussion should have been public because the sheriff was a common facilitator who received comments from each commissioner in front of the other commissioners. More recently, in City of Bradenton Beach versus Metz, number 2017, California, 003581, Florida 12th Circuit Court, August 9th, 2019, members of a city planning and zoning commission violated the Sunshine Law when they participated in discussions at meetings of a community improvement organization which involved planning and zoning matters. The trial judge found their continued participation particularly problematic, especially since the city attorney had expressed Sunshine Law concerns. Next, on page 22, we address confidential records discussions. The Florida Supreme Court has clearly stated that in the absence of a statute exempting a meeting where privileged material is discussed, Section 286.011, Florida statutes, should be construed as containing no exceptions. City of Miami Beach versus Burns, 245 Southern 2nd, 38, Florida, 1971. A key amendment to the Public Records Act in 1991 clarified this. After several district courts had held that certain proceedings could be closed when considering confidential material, Section 119.07, subsection 7, Florida statutes, was added. It explicitly states that an exemption from Section 119.07, Florida statutes, does not imply an exemption from Section 286.011. The exemption from Section 286.011 must be expressly provided. This means that exemptions from the Public Records Act do not, by implication, allow a public agency to close a meeting where exempt records are to be discussed, unless there is a specific exemption from the Sunshine Law. See Attorney General Opinions 10-04 and 91-75, School Board, 04-44, Pride, 93-41, County Criminal Justice Commission, and 91-88, Pension Board. For example, while Section 288.075, Subsection 2, Florida statutes, allows a private corporation to request confidentiality for certain records related to a planned corporate relocation to Florida, this exemption applies only to records and does not constitute an exemption from the provisions of the government in the Sunshine Law. This was noted in Attorney General Opinion 04-19, Accord Attorney General Opinion 80-78, and Informal Opinion to Rooney, June 8, 2011. In Attorney General Opinion 05-03, the Attorney General advised that a federal law prohibiting the disclosure of certain identifying information did not authorize a state committee to close its meetings. However, the committee should take steps to ensure that identifying information is not disclosed at such meetings. And see Attorney General Opinion 12-20, which states that a county transportation board designated as an appropriate local official authorized by statute to receive and investigate whistleblower complaints must comply with the open meetings requirements in the Sunshine Law. Nevertheless, the board must also protect the confidential information it is considering at a meeting and must not disclose the name of the whistleblower unless one of the specific circumstances listed in the statute is present. Compare Attorney General Opinion 96-40, which states that a town may not require a complainant to sign a waiver of confidentiality before accepting a whistleblower's complaint for processing, since the legislature has already provided for the confidentiality of the whistleblower's identity. Similarly, in Attorney General Opinion 96-75, the Attorney General's office advised that since under Section 286.011, Subsection 8, Florida statutes, the transcript of a closed attorney-client session becomes open to public inspection. Once the litigation is concluded, the city and its attorney should be mindful of any discussions of confidential medical reports during such a meeting. They should take precautions to protect the confidentiality of such medical reports so that when the transcript is open for inspection, the employee's privacy is not breached. Compare Everglades Law Center, Incorporated versus South Florida Water Management District 290, Southern 3rd, 123, Florida 4th District Court of Appeal, 2019, noting that the statements made in Attorney General Opinion 96-75 regarding taking steps to protect confidentiality and privacy applied to an individual's medical record in the context of a workers' compensation claim and did not address the confidentiality of mediation communications involving information regarding multiple persons. The court emphasized that these mediation communications are confidential pursuant to Sections 44.102, Subsection 3, and 44.405, Subsection 3, Florida statutes, and should be redacted from the full public transcript. Segment 3, email, text messages, and other written communications between board members. Finally, let's look at email, text messages, and other written communications between board members on page 23. The Sunshine Law mandates that boards meet in public. This means boards may not take action on or engage in private discussions of board business through written correspondence, emails, text messages, or other electronic communications. Thus, members of an advisory committee created to make recommendations to the superintendent on school attendance boundaries violated the Sunshine Law when they exchanged private electronic communications, emails, and Facebook messages relating to committee business. Linares versus District School Board of Pasco County, number 17-002, 30, Florida 6th Circuit Court, January 10, 2018. See also Attorney General Opinion 89-39, which states that members of a public board may not use computers to conduct private discussions among themselves about board business. Similarly, city commissioners may not use an electronic newsletter to communicate among themselves on issues that foreseeably may come before the commission. Informal opinion to Circus, October 31st, 2000, and C, Attorney General Opinion 09-19, which advised that members of a city board or commission may not engage on the city's Facebook page in an exchange or discussion of matters that foreseeably will come before the board or commission for official action. Informal opinion to Martelli, July 20th, 2009, further emphasizes that an authority should discuss business at publicly noticed meetings rather than in a series of letters between authority members. Compare informal opinion to Galatic, October 19th, 1995, which noted that school board members may share a laptop computer even if it contains individual members' ideas, as long as it's not used for communication between members. Thus, a procedure where a board takes official action by circulating a memorandum for each board member to sign, indicating approval or disapproval of an issue, violates the Sunshine Law. Informal opinion to Blair, May 29, 1973, and C, Leach Wells versus City of Bradenton, 734, Southern 2nd, 1168-1171. Florida 2nd District Court of Appeal, 1999, where a selection committee created by a city council violated the Sunshine Law when the city clerk unilaterally ranked proposals based on individual written evaluations. The court held that the shortlisting was formal action that was required to be taken at a public meeting. See also Schweikert versus Citrus County Port Authority number 12-California-1-339, Florida 5th Circuit Court, September 30th, 2013, where an ad hoc committee appointed by a board violated the Sunshine Law when members submitted individual written evaluations to staff for compilation and ranking. The court ruled the committee should have ranked proposals at a public meeting, and Attorney General Opinion 93-90 advises against using a review procedure where individual board members compile CEO evaluations for private discussion with the CEO. Compare Carlson versus Department of Revenue, 227 Southern 3rd, 1261, Florida 1st District Court of Appeal, 2017, which held that a state agency evaluation team members who individually evaluated, scored, and submitted proposals were not obligated to conduct a public meeting, as they did not take formal action. However, a commissioner may send a written report to other commissioners on a subject to be discussed at a public meeting without violating the Sunshine Law, provided there is no prior interaction related to the report among the commissioners, and the report, which must be maintained as a public record, is not used as a substitute for action at a public meeting. Attorney General Opinion 89-23, and see Attorney General Opinion 01-20, which clarifies that email communication of information from one council member to another is a public record, but does not constitute a meeting subject to the Sunshine Law when it does not result in the exchange of council members' comments or responses on subjects involving foreseeable action by the council. Compare informal opinion to Kessler, November 14, 2007, which states that a procedural rule requiring a county commissioner to make a written request to the commission chair to withdraw an item from the consent agenda does not violate the Sunshine Law. If, on the other hand, the report is circulated among board members for comments, with such comments then being provided to other members, this constitutes interaction among the board members that is subject to Section 286.011 Florida Statutes, Attorney General Opinion 90-03. Similarly, in Attorney General Opinion 96-35, the Attorney General's office concluded that while a school board member may prepare and circulate an informational memorandum or position paper to other board members, the use of a memorandum to solicit comments from other board members or the circulation of responsive memoranda by other board members would violate the Sunshine Law. Such action would be equivalent to private meetings discussing the public business through the use of memoranda without allowing an opportunity for public input. In addition, the Attorney General's office stated that while it is not a direct violation of the Sunshine Law for members to circulate their own written position papers on the same subject, as long as the board members avoid any discussion or debate among themselves except at an open public meeting, this practice is strongly discouraged. Attorney General Opinion 07-35. See also Attorney General Opinion 01-21, which states that a city council's discussions and deliberations on matters coming before the council must occur at a duly noticed city council meeting, and the circulation of position statements must not be used to circumvent the requirements of the statute. Attorney General Opinion 08-07 advises that a city commissioner may post comments regarding city business on a blog or message board, but any subsequent postings by other commissioners on the subject of the initial posting could be construed as a response subject to the Sunshine Law. An informal opinion to Jove, January 22, 2009, addresses the posting of anticipated votes on a blog. This concludes our in-depth look at the scope of the Sunshine Law and how it applies to various forms of communication and interaction between board members. Thanks for listening. In our next episode, Episode 5, we'll continue exploring what meetings are covered, focusing on informal discussions, investigative meetings, and litigation meetings. Until next time, remember, the truth dies in the dark, so let's leave the light on.